On the issue of whether you're trying to squeeze an elephant into a mouse hole, and the question of whether this is fundamentally different from anything that OSHA has ever done before, I want to see if it might be fundamentally different in at least two respects and get your answer to the question. Most OSHA regulations, all of the ones with which I'm familiar, affect employees when they are on the job, but not when they are not on the job. And this affects employees all the time. If you're vaccinated while you're on the job, you're vaccinated when you're not on the job. Isn't this different from anything OSHA has done before in that respect?
So two responses to that. First, of course, there's also a mask and test option here. So I think even on that analysis.
Right now I'm talking just about the vaccines.
So focusing just on vaccination, I think that that's a way to describe it, that it also provides protection when you're not at work. But OSHA was directly targeting and trying to provide the protection at work. And I don't think there's any basis in the text of the statute to think that this kind of protection is off limits.
Suppose this is a little science fiction, but maybe it will illustrate a point. Suppose that this protection were provided not by the administration of a vaccine, but by waving a wand over employees when they arrive at work. And suppose that wand also had the capability of taking away this protection when the employee leaves work. Would OSHA have the authority to tell employees, you must have this wand waved over you when you arrive, but you can't have it taken off when you leave?
No, I don't think that OSHA would have that authority.
All right, so it's different in that respect. And here's another respect in which it may be different. And I don't want to be misunderstood in making this point, because I'm not saying the vaccines are unsafe. The FDA has approved them. It's found that they're safe. It's said that the benefits greatly outweigh the risks. I'm not contesting that in any way. I don't want to be misunderstood. I'm sure I will be misunderstood. I just want to emphasize I'm not making that point. But is it not the case that these vaccines, and every other vaccine of which I'm aware, and many other medications, have benefits and they also have risks? And that some people who are vaccinated and some people who take medication that is highly beneficial will suffer adverse consequences. Is that not true of these vaccines? And if that is that true?
That can be true, but of course there is far, far greater risk from being vaccinated by orders of magnitude.
Right, there is some risk. Do you dispute that?
There can be a very minimal risk with respect to some individuals, but again, I would emphasize that I think that there would be no basis to think that these FDA-approved and authorized vaccines are not safe and effective.
No, I'm not making that point. I tried to make it as clear as I could. I'm not making that point. I'm not making that point. I'm not making that point. There is a risk, right? Has OSHA ever imposed any other safety regulation that imposes some extra risk, some different risk on the employee, so that if you have to wear a hard hat on the job, wearing a hard hat has some adverse health consequences? Can you think of anything else that's like this?
I can't think of anything else that's precisely like this, but I think that to suggest that OSHA is precluded from using the most common, routine, safe, effective, proven strategy to fight an infectious disease at work would be a departure from how this statute should be understood.
Can I just say, General, that regulators think of risk trade-offs constantly when they make regulations? That there are constant situations in which there are risk trade-offs. Risks on both sides, but one risk vastly outweighs another risk, and that comes up throughout regulatory space.
That's absolutely true, and one of the risks that OSHA was guarding against here was the risk that unvaccinated workers pose to other workers, because they are so much more likely to transmit this deadly disease to them.
What type of workers? To vaccinated workers?
Yes, the grave danger finding was based on unvaccinated workers.
I thought the Secretary disclaimed that.
Yeah, the grave danger finding is limited to unvaccinated workers who are far more likely to contract it from their coworkers as well.
That's not a concern for us, is it? We can't sustain this on that ground, that this is helpful to the vaccinated workers because the unvaccinated workers present a risk to them.
Oh, to be clear, they present a risk to other unvaccinated workers who might be older, who might have other comorbidities.
All of whom have balanced the risks differently, maybe very foolishly, but they want to balance the risks presented to their health in a different way. And OSHA says, no, you can't do that. And that applies when you're on the job and also when you're not on the job and for the rest of your life, because you have to take these vaccines, unless the testing option is valuable.
Well, one small factual correction, if I could, and then a broader legal point. I think it's wrong to say that everyone who's unvaccinated is just assuming the risk. Some people can't get vaccinations for medical reasons. Some people have deeply held religious beliefs and are entitled to religious exemptions. And OSHA is entitled to try to protect those unvaccinated workers, no matter the reason they're unvaccinated. Just on the broader legal point, the idea that OSHA is powerless to act to protect workers if they simply want to assume the risk is inconsistent with how the OSHA Act has been understood throughout its history. OSHA frequently requires employers to require that the employees use protective gear or take precautions.
Isn't it the case that most of the time there's this strong reason for saying that it isn't a defense to an OSHA Act charge that the employers assumed the risk voluntarily, that under most circumstances employers have an incentive to avoid compliance with, to avoid the costs and inconvenience of a regulation. And so we don't want to put the employees under pressure, overt or implied, to waive the protection of a regulation, a protective regulation. But there's no such incentive here. They're free, the vaccines are free, and to the extent they keep workers healthy and on the job, it's in the interest of the employers to have them vaccinated.
Well, certainly the fact that workers in the past have not wanted to use certain protections has not provided a defense to regulations that have been issued under the OSHA Act.
Did the states have clear notice that by accepting Medicaid funds, they would be subject to vaccination requirements for staff at their state-run facilities?
So the facilities, and this applies to all facilities in Medicaid and Medicare, not to the states as the administrators of their own Medicaid programs, but I acknowledge states do have state-run facilities. All of them are on notice that they're subject to the health and safety requirements that the Secretary may adopt from time to time. Obviously, they didn't have specific notice of the vaccination requirement because it didn't exist until the pandemic came about, but the way that the program operates is that all providers are on notice that they have to comply with the Secretary's regulations, which could change.
So if they read the statutes that you are now relying on primarily, that would provide them clear notice that they might be subject to something like this vaccination requirement?
It would put them on clear notice that they are subject to such requirements as the Secretary finds necessary in the interests of patient health and safety, which have long included infection control. In the past, that's been general. It's been requiring infection control plans that meet national guidelines, fire preparedness, emergency safety, things of that nature. So they have long been on notice that they are subject to requirements by the Secretary in the interest of patient health and safety. And I think this is a sort of heartland case of a measure to protect patient health and safety in the midst of a pandemic.
I don't have before me the particular statutory provision that you spoke of earlier, but is it the case that some of many, if not all, of these additional statutory provisions on which you are now placing your principal reliance are definitional provisions rather than provisions that expressly authorize the Secretary to promulgate regulations? Is that correct or incorrect?
They're both. So they are definitions. The provision I quoted earlier, 1395 XE, is the definition of a hospital for purposes of the statute.
Right.
But in that definition, it says a hospital, and what it means to be a hospital is to be eligible for Medicare reimbursement. What it means to be a hospital is to meet the following specified requirements, including such other requirements as the Secretary finds necessary. So,
right. But it doesn't say the Secretary is authorized to promulgate any regulations that protect the health and welfare of people in a hospital or in any of these other facilities. It says that the definition of a hospital and the definitions of these other facilities, by definition, they are facilities that are required to comply with regulations.
As the Secretary finds necessary in the interest of patient health and safety, yes.
Is there any limit to that power? What could the Secretary, what, if anything, could the Secretary not do if the Secretary finds that something is necessary to protect the health and safety of people in those facilities?
Well, I think the major limit is the one in the text of the statute itself. The Secretary has to find that it's a requirement that's in the interests of patient health and safety, as the Secretary did here. I think the other constraints on that authority are the types of health and safety measures that you see in healthcare providers. So, and the way you know that this provision is within the Secretary's authority is that you see providers adopting it on their own. You see medical societies like the American Hospital Association, the AMA, the American Nurses Association recommending this policy. You see some states adopting this policy. I think all of those things are powerful confirmations that this is a routine, common, effective measure for protecting patient health and safety.
One of the arguments on the other side is that you were required by statute to consult with the states before you did this. What is your response to that?
There is a provision of the statute that says that when the Secretary sets conditions of participation for some of the providers at issue here, in carrying out that function, he shall consult with the states. The statute doesn't say that that consultation has to happen before rulemaking, and the way that the Secretary has long understood that to function is to require consultation in conjunction with the notice and comment process.
Isn't that an odd understanding of a consultation requirement? We're going to tell you to do something, and then after we've told you to do it, we're going to consult with you about what we've already said you have to do.
I don't think so, Justice Alito, in the context of the provisions of the statute that also contemplate, as the APA does, that in some circumstances the Secretary will have good cause to act without notice and comment. So in the ordinary case, there's going to be notice and public comment, which has the benefits that Justice Barrett referred to earlier. When that happens, you should also be sure you consult with the states and with accrediting boards. But when there's good cause to skip that, the agency has long interpreted that to mean that it can defer consultation with the states to the parallel public comment process.
Is there a good cause exception in the provision that requires consultation?
There isn't, but there's no temporal requirement at all. So it's actually the other side that's asking you to read into that a requirement that had happened before rulemaking and to make that requirement apply even when the good cause exception is satisfied. And we don't think there's any basis to do that, certainly not in the Secretary's past practice. This has long been the way that the Secretary has interpreted this provision in conjunction with the good cause exception to notice and comment.
Mr. Fletcher, can I follow up on the questions that Justice Thomas and Justice Alito have been asking about the facility-specific statutes? I think it was wise to shift your focus to those because of their references to health and safety. But I find it difficult because the language of each of those statutes is different, and not all of them reference health and safety. So, for example, I think the one on long-term care facilities is your best, because that's the one that also refers to or requires skilled nursing facilities to establish and maintain an infection control program. That one, I think, gives you a stronger case than the ones that don't mention health and safety at all. Or, for example, for ambulatory surgical centers, you know, the provision on which you rely describes the benefits provided to an individual, and then it lists the kind of services that would be covered, right? And then parenthetically, it says, performed at an ambulatory surgical center, parentheses, that meets health and safety and other standards specified by the Secretary. It seems to me a heavier lift to say that that kind of aside in a parenthetical is a grant of authority to CMS to impose this kind of vaccination requirement on those who work at the ambulatory surgical center. So I guess my question is this. One, you know, the government here seeking the stay of the injunction has the burden of showing likelihood of success on the merits, and I understand because of space limits and the number of statutes on which you're now relying, it would be hard to make the specific case for each of these provisions. But what if I think some of the provisions might support you and others don't? This was an omnibus rule, and even though the Secretary in a chart identified all these, you know, specific provisions, we don't really have before us the structural and textual arguments directed at each of these provisions. So what if I think some do and some don't? In an omnibus rule, what am I supposed to do?
Well, so we agree entirely that the focus ought to be on the statutory text, and one of our complaints with the district court decisions in these cases is that they blew past all of those distinctions and didn't focus on the text at all. So we absolutely agree the text of these provisions should be the court's focus. In terms of how to think about them, I understand it's unwieldy. There are 15 different provisions. I would group them into two categories. There are 11 or so that we cite at pages 5 to 6 of our reply brief that include that specific health and safety language in different formulations, but all of them specifically referring to requirements in the interests of patient health and safety. And as we've explained, we think that this is the paradigmatic health and safety regulation, and that's reinforced by the consensus of the medical community, by other regulators, by practices of providers. Now, there are a few statutes that we cite at page 9 of our reply brief that don't include that specific language. Those statutes are the ones applicable to providers that employ about 3% of all of the workers covered by the rule. Now, our view is that all of those statutes still give the Secretary the authority to set standards or requirements for participating providers. And if you look at those provisions, what you find is that Congress was a little bit less detailed. In the hospital provision, the 1395XE9, the preceding 8 sections all detail relatively nuanced, very specific requirements for hospitals. And then the
arguments, the following: a party cannot challenge the constitutionality of a law that imposes an allegedly unconstitutional restriction on the exercise of a right if the party could have very easily satisfied the preconditions for the exercise of the right.
I think we would probably say that, but I don't think it is necessary for the court to go that far to resolve the case in this.
How can that possibly be the law? Suppose a state university says that no person of a particular race may enter any of the university buildings unless that person pauses for 2 seconds, stands still for 2 seconds before entering the building. Would you say, well, you can't challenge that racial restriction because it's no big deal to pause for 2 seconds before you go into the building?
I mean, the court in a case like that might say, in the context of race discrimination, that the mere fact of being subject to racially disparate treatment is injury in fact, regardless of whether any other concrete consequence comes of that. And the court has said, for example—
Do you think that's limited to an unconstitutional instance of racial discrimination? It wouldn't apply to the other, to free speech rights?
Well, it's certainly true in general that in order to establish standing, a plaintiff has to allege and then show not just a deprivation of a legal right, but some practical injury. But
no newspaper may run an editorial criticizing the president unless it's in a particular font?
I guess the reason I would say that the court doesn't need to address those more difficult hypotheticals is that at least in order to challenge a limitation like that, the newspaper would have to allege, were it not for this restriction, we would use a different font. What makes this case particularly easy in our view is that appellees could have avoided their injury by doing precisely the thing that they would have done if the statute and regulation were not on the books.
Let me give you one more example. A town passes an ordinance that has 2 sections. Section 1 says no newspaper may run an editorial criticizing the mayor except as provided in Section 2. Section 2 says any editorial criticizing the mayor must be published within, criticizing a speech made by the mayor must be published within 20 days after the speech. Would the newspaper, after the 20 days passed, have standing to challenge Section 1 or only Section 2?
I'm sorry, could you?
Yeah, okay, it's a little complicated. So, town passes an ordinance. Section 1, no newspaper may run an editorial criticizing any speech delivered by the mayor except as provided in Section 2. Section 2, any editorial criticizing a speech delivered by the mayor must be published within 20 days after the mayor's speech. Can the newspaper, after the 20 days have passed, challenge Section 1 or only Section 2?
Well, I think they could probably challenge both, but they would have to say, were it not for this legal restriction, we would publish an editorial critical of the mayor after 20 days.
Where does this? Justice Alito?
I'd like your response to the argument that these racial categories are so broad that any use of them is arbitrary and therefore unconstitutional. So what would you say to, for example, a student whose family came from Afghanistan and doesn't get in because the student doesn't get the plus factor that the student would get if the student's family had come from someplace else. So you would say to the student, well, we don't need you to contribute to a diversity of views at our school because we already have enough Asians. We have a lot of students whose families came from China or other Asian countries. And the student says, well, you don't have anybody like me. I'm from Afghanistan. What similarity does a family background of a person from Afghanistan have with somebody whose family's background is in, let's say, Japan?
So respectfully, what you're describing is the exact opposite of how our process actually works on an individualized basis. We discussed this on page 11 of our brief. There was a Vietnamese student. The admissions officer testified about a Vietnamese student who immigrated to a remote part of North Carolina and thrived in that setting. And she testified, undisputed, that was a favorable aspect of her application.
That's an individual aspect of the application and something that has to do with her experience. But what is the justification for lumping together students whose families came from China with students whose families came from Afghanistan? What do they have in common?
So I agree that would be a strange rule, and that is not the rule that this court has established.
Well, then why do you have them check a box that I'm Asian? What do you learn from the mere checking of the box?
So we think that it depends on the individual circumstances of that person. But
so you don't need the boxes at all.
So I think that is not necessarily true on an individualized basis. So another example. So we, again, as I discussed, we attempt very vigorously to recruit and enroll rural students. And we don't ask them to write their essay about how being from a rural background affects their sense of self and their experiences. But what we say is that person comes with something that we value.
Well, they may choose to write about it. But what's the answer to my question? Why do you have these boxes? Why do you give a student the opportunity to say, this one thing about me, I'm Hispanic, I'm African American, I'm Asian. What does that in itself tell you?
We think that it can, in context, on a individualized basis, perhaps not in every case, but in some cases, give important information about where that person is coming from, what their experiences have been. And really, this goes to the heart of the dispute that we have between the parties. So they say on page 53 of their brief that race says nothing about who you are. And we just don't think that is true when you look at American society as it exists. We think that in the context of everything else that we know about an applicant, it can matter, not always, and there's no automatic plus factor that's given, but it can matter what an applicant's racial background is.
Let me just ask one more related question, and that is, the circumstance, this is a real problem, and I've heard it described to me by people who face it. When can a student honestly claim to fall within one of these groups that is awarded a plus factor? So let's say the student has one grandparent who falls within that class. Can the student claim to be a member of an underrepresented minority?
Yes, we rely on self-reporting, and we don't give it.
One great-grandparent.
If that person believes that that is the accurate expression of their identity, I don't think there would be any.
One great-great-grandparent. You're going to make me continue to go on.
Right. I think that as we go on, I agree that it would seem less plausible that that person would feel that this is actually capturing my true racial identity. But the same is true for any of the other diversity factors that we.
It's family lore that we have an ancestor who was an American Indian.
So I think in that particular circumstance, it would be not accurate for them to say, based on.
I identify as an American Indian because I've always been told that some ancestor back in the old days was an American Indian.
Yeah, so I think in that circumstance, it would be very unlikely that that person was telling the truth. And the same is true for, we rely on self-reporting for all the demographic and other characteristics that we ask for. And there's nothing special about the racial identification on that score, Your Honor.
Justice Alito?
You make some very good points in your brief, but reading it, I was struck by the fact that the word Asian does not appear one time in your brief. Yet Asian Americans have been subjected to de jure segregation. They have been subjected to many forms of mistreatment and discrimination, including internment. So do you have anything to say this morning about the interests of students of Asian background and how your arguments impact them?
Yes, Your Honor. So 2 points. One is that discrimination against Asian Americans is wrong. It's bad. We do not condone it at all. But 2, our brief actually reflects the record in this case. There were no claims developed by petitioner involving the mistreatment or maltreatment of Asian American students. And I think that was one of the problems that happened with the first brief, is that they conflated their arguments against Harvard, which Mr. Waxman will adequately defend shortly. But those arguments conflated the issues. There's no racial balancing claim against UNC. There's no allegation of quota. There's been a lot of talk about quota in this case. There's no claim about that. There's no claim against UNC involving the intentional discrimination against Asian American students vis-a-vis white students or other students. So that record actually doesn't exist.
So what is your response to the simple argument that college admissions are a zero-sum game? And if you give a plus to a person who is falls within the category of underrepresented minority, but not to somebody else, you are disadvantaging the latter student.
And Your Honor, that's an excellent point, but the record actually bears out about how, in this case, how the holistic admissions plans does end up operating. And it is where an individualized consideration is being made on a student's own talents, on a student's own achievements.
So you're saying that race in and of itself has no effect at the University of North Carolina?
Absolutely not, Your Honor.
Okay, then you would have no objection to an opinion from this court saying you may not consider race. You may consider other things, but you may not consider the mere fact of race, period. You would have no objection to that.
Your Honor, I don't know if I'm answering your question with a negative and a double negative here, but I do want to make clear that we fully support the limited consideration of race as it has been authorized by this court.
Well,
again,
then
it is
I just
only
don't,
on an individual.
I don't understand your answer. Either if it's irrelevant, then you shouldn't care whether it's ruled out.
And we're not, if I'm articulating that, Your Honor, I'm not meaning to. We certainly believe that race within the context of an applicant may be considered as a plus factor. That's not
Race in
only
itself may be considered a plus factor.
Yes, Your Honor.
And therefore, those who don't get the plus factor have what is essentially a negative factor.
No, Your Honor.
It's not the same thing?
No, Your Honor, it's not, because it's looking at the whole applicant as they apply within their whole application and their resume, et cetera.
Suppose you have a race, 2 people are in a race, and you give a plus factor to one of the runners. So that runner gets to start, well, if it's a 100-yard dash, let's say it gets to start 5 yards closer to the finish line. The one who doesn't get that plus factor is disadvantaged, right?
That would be in that case, but that case is not here. There are no bonus points that are provided to any applicant at the University of North Carolina. That is fully prohibited by this court's decision in Gratz, and we're not suggesting that it should be reinstituted.
Waxman, let me stop you there because you referred to the personal score. And that's a score that Harvard gives based on character traits such as integrity, courage, kindness, and empathy. But the record shows that Asian student applicants get the lowest personal scores of any other group. What accounts for that? It has to be one of 2 things. It has to be that they really do lack integrity, courage, kindness, and empathy to the same degree as students of other races, or there has to be something wrong with this personal score.
That is, I mean, I want to get to what the evidence was there, but that syllogism, with all due respect, is wrong. There was, for example, a study that was done in 1983 that looked at why it was that female applicants to graduate school at the University of...
No, just address this. The personal score that's given to Asian applicants to Harvard, why are they given a lower score than any other group?
Okay, so the answer to why they, as a group, why there is a slight numerical disparity with respect to the personal rating of Asian Americans, and also a slight numerical disparity to the advantage of Asian Americans with respect to the extracurricular rating and the academic rating, was the answer that their expert gave with respect to the latter two, which is that the only way that the only model that can be created to figure out what was going into the personal rating couldn't look at almost anything that admissions officers look at in those ratings. It can't, there's no way that it could model what the guidance counselor letters said, what the teacher letters said, what the essays said, what the interviewers' letters said. In other words,
I thought the interviewers did not rate the applicants lower than other applicants based on race. There was not the disparity in what was said by the interviewers.
With respect to the alumni interviewers, based on the subset that was included here, their subset, by the way, excluded all ALDC applicants. That is, even though they acknowledged that there was not only no evidence of discrimination against Asian American ALDCs, but they did better. They eliminated from their model applicants that represent, on average, 30% of the admitted class.
I still, putting aside the teacher recommendations or guidance counselor recommendations, which I'll come to, I still haven't heard any explanation for the disparity between the personal scores that are given to Asians. They rank below whites, they rank way below Hispanics, and really way below African Americans. And you're talking about hundreds and hundreds of applicants, maybe thousands. What is the explanation for that?
So the explanation that was, I can't do better than the findings of fact in the trial court as affirmed, but I want to make 2 points very clear with respect to your question. All of this was on display and in front of the trial court for this Asian American part of it for well more than a week, maybe 2 weeks. The district court found, considering all of the evidence, that there is, quote, no credible evidence that corroborates the improper discrimination suggested by SFFA's interpretation of the personal rating, page 264.
All right, I'll try one more time. The district court found, quote, a statistically significant and negative relationship between Asian American identity and the personal rating assigned by Harvard admissions officers.
That's correct. And what she said is the record will not allow a full explanation of that because there was no evidence with respect to what teachers said, what guidance counselors said, what these students wrote about. But what we can say with respect to the allegation of discrimination in this case, which was the definition of discrimination that was at issue in Bakke and Grutter and Fisher, and which their lawyer got up at opening statement and said, when we talk about discrimination, in this case, we're talking about discrimination in admissions outcomes. And here again, the district court found, and the Court of Appeals also concluded, that there was no evidence of discrimination in admissions outcomes against Asian Americans, whatever you think about the personal rating, which is, after all, simply a number
Justice Alito would like to ask a question.
I'm sorry. I'm not trying to filibuster you.
Finish your sentence, then I will ask one more question.
I want to make one other thing clear to the extent that it's not clear from the record. The personal rating, like the academic rating and the extracurricular rating and the athletic rating, is a number that is put down by a, quote, first reader. That is, the file comes in, it's not usually complete, and just as a matter of triage, one of the 40 admissions officers goes through and gives these numerical numbers. The testimony was, it is not considered in any way once the subcommittees and committees meet. It, quote, fades into the background. It is not the basis of admissions decisions. And so not only did the court find as fact that that slight disparity was not evidence of discrimination, even in the personal rating, it had no effect with respect to outcomes.
It makes no difference whatsoever?
It's not that it makes no difference whatsoever. Look at what the expert testimony was, and I realize
Does it make a difference or doesn't it make a difference?
It doesn't make a statistical difference in admissions outcomes.
Then why do you do
both
it?
courts found.
Why do you do it?
It
doesn't matter. Why do you do it?
We do it as a matter of triage. Right now, Harvard is last year got 61,000 applications for 1,600 slots. And it is an entirely rational way of figuring out how you are going to allocate your attention to ask an admissions officer as the file is being developed, just go through in a very rough way and rate a particular application based on what you can see on these 4 metrics. The fact that Asian Americans got on average, a marginally lower personal rating score is no more evidence of discrimination against them than the fact that they got a marginally higher rating than any data can show on academics and extracurriculars. It doesn't mean that they're either smarter or people think they're smarter.
Thank you, counsel.
Well, I don't understand the state's argument to depend on the proposition that the executive must detain everybody, even if it doesn't have the capacity to detain them. I understood their argument to be centered on something quite different. So let's just assume, for the sake of argument, that there isn't an issue about how many people you were going to detain, but only a question about which ones you were going to detain. And the problem that I see with your final memorandum is that Congress has established its own set of priorities and has said that certain categories of aliens must be detained, shall be detained. And the final memorandum tells ICE officers, don't do that. Don't detain anybody based solely on that person's criminal history. You must make a totality of the circumstances decision about every single alien who you're considering for detention. Isn't that correct?
No, that's incorrect. And let me be really clear about how the guidelines operate with respect to detention. They don't govern the question of continued detention at all. They're focused on apprehension and removal, and therefore, when DHS officers have someone in custody and there are pending removal proceedings, the guidelines leave it to the statute to dictate those kinds of detention decisions, and DHS does treat 1226C2 as mandatory in that circumstance.
Let me ask you about another case. Is it the position of the United States that the states lacked standing in the Little Sisters of the Poor case from 2 years ago because their expected additional health care spending was an indirect injury?
Justice Alito, I can't recall whether the government made standing arguments in that case.
Well, I'm just asking you now. What do you think about that? The argument was that the states, Pennsylvania, I believe, and another state had standing because the regulation they were challenging would have the effect of imposing, it would remove health care from certain residents, students who were away at college in other states, and thereby impose an additional cost on the states. Was that wrong?
So if I understand the facts of the case correctly, I think that it's possible that that would constitute the kind of direct injury that this court's precedents have recognized in this space if the challenged regulation operated directly on the states with respect to dictating, for example, their federal funds or requiring regulating them directly.
No, they just said that they would have to pick that up under state programs. Well, let me move on to something else. On this indirect, direct injury distinction that you're drawing, should we hold that an indirect injury is never injury in fact for Article 3 purposes for all plaintiffs?
No, we're not asking for that. So we think that this is a distinctive principle that the court has applied when states are seeking to vindicate sovereign or quasi-sovereign interests. And the reason for that, I think the reason the court's precedents recognize that the states are then under an obligation to show this form of direct injury is about our constitutional structure. It's
so
about
this is a special standing rule for states that disfavors state standing.
Well, let me be perfectly clear that when the states are seeking to proceed on the basis of proprietary harms, the same kinds of interests that other private litigants can bring, we think that the same rules apply.
Yes, but an injury that would be sufficient for Article 3 purposes for an individual or for a private entity is not sufficient, in your view, for the states. There's a special rule for the states.
With respect to quasi-sovereign and sovereign interests, yes. And the reason that
so
we
this
think
is
the
a
court
rule of special hostility to state standing. How is that consistent with Massachusetts versus EPA, where the court said that there is a special solicitude for state standing?
Special solicitude, as we understand it in this court's precedents, reflects the fact that states have more theories of injury available to them. So they're not limited to the same proprietary interests that other parties can assert with respect to their contract rights or being regulated as an employer. Instead, special solicitude reflects the fact that states can also seek to proceed on the basis of sovereign or quasi-sovereign harms. But I don't think it's right to suggest that the court's rules or framework in this area amounts to hostility. This is about recognizing that when one sovereign is suing another sovereign under our constitutional structure, that implicates fundamental constitutional principles. And I think a contrary rule would effectively mean that states can sue about anything.
You don't like the word hostility, but you have a special rule for state standing that disfavors the states. The states are in a less favorable position than they would have been if they were a private entity or an individual. Let me move on to one other case. Do you concede that Federal Election Commission versus Atkins acknowledges that Congress can permit civil actions challenging non-enforcement decisions?
Yes, in that case, I recognize that the court concluded, obviously, over Justice Scalia's dissent, but that is an example where the court allowed standing in that circumstance.
And why doesn't that principle apply here?
Well, I think that the more on-point precedent in this case is Shurtan, where the court specifically took the Linda R.S. principle and said that it applied in the realm of immigration law as well.
Justice Thomas? Justice Alito?
Well, I want to come back to the last question that I asked you and break it down. And I hope you can give me a succinct answer to these questions that I'm going to ask. If shall means shall, is there well, let me amend that. Does the statute say that an alien who has been convicted of an aggravated felony shall be detained?
Yes. It says that in Section 1226C.
And I'm looking at the final memorandum, pages 114 to 115 of the Joint Appendix, where you set out certain aggravating factors, which includes a serious prior criminal record, the gravity of the offense of conviction, and the sentence imposed, and then a list of mitigating factors, advanced or tender age, mental condition, various others, military or public service. And then you say on 115, our personnel should not rely on the fact of conviction or the result of a database search alone. Now, that's what I was getting at. Congress has set out certain priorities with respect to an alien convicted of an aggravated felony. It says that person shall be detained. And what your final memorandum says is no, that person shall not be detained based solely on this prior conviction for an aggravated felony. You have to take into account that as one of the aggravating factors, and then all of these mitigating factors, and then the officer must make a determination. So we have one set of priorities established by Congress and a different set of priorities established by the executive branch. Isn't that correct?
No, that's wrong, because the guidelines govern only decisions about apprehension and removal, whether to charge a non-citizen in the first place. And I think that the kind of mismatch here is that 1226C governs when DHS has already made the charging decision, so there are pending removal proceedings. And at that point, if we have a non-citizen in custody, we will detain them if they're described in Section 1226C. ICE does not make release determinations without running that analysis. And so I don't think that there is any fundamental override here of the detention provisions, because the guidelines don't have anything to do with continued detention.
Well, my question really was not whether this website is a public accommodation. I understand that's been stipulated. That wasn't my question. What I'm trying to understand is the breadth of your argument. And what I get is that you're making a tiny sliver of an argument. So the website can put anything on its website, even something that will blatantly or subtly tell a same-sex couple, well, this is not a service that I want. They can do that. And the website can also potentially get itself out from being a public accommodation simply by reserving a degree of selectivity. That's what you've told me so
No, I don't think it's just by reserving a degree of selectivity, but I think the more selective and sort of curated the process is, it makes it less likely to be a public accommodation, as the court recognized in Fulton.
All right, let me ask you, and then I'll finish this line, some hypotheticals in a brief submitted by Josh Blackman. A Jewish man and a Jewish woman who were engaged to be married ask a Jewish website designer to build a website to celebrate their their nuptials. No problem, okay? Another Jewish man and a Christian woman who were engaged to be married ask a Jewish website designer to build a website to celebrate their nuptials. Big problem. Quote, many Jews consider intermarriage an existential threat to the future of Judaism. Does that website have to accept the second couple?
Again, as we talked about before, if the Jewish website designer has, very explicitly Jewish themes on the wedding, they don't need to on the website. They don't need to take that down for the inter-religious couple that comes. But if they offer a general service to the public, they need to offer that regardless of the customer's religion.
So the fact that they offer this that this is a Jewish, that is offered mostly to Jews, that's enough to make it, or exclusively to Jews, that's enough to make it sufficiently selective to get them out from your...
No, I'm drawing a distinction between what the website designer chooses to put on the website and who the website designer sells the website to. The website designer can choose to put on their websites whatever they want, but they just can't refuse to sell, if they're a public accommodation, they can't refuse to sell that website to someone solely because of their customers or the couple's religion.
Okay, an unmarried Jewish person asks a Jewish photographer to take a photograph for his J-Date dating profile. Is it a dating service, I gather, for Jewish people?
It is.
All right, maybe Justice Kagan will also be familiar with the next website I'm going to mention. So next, a Jewish person asks a Jewish photographer to take a photograph for his ashleymadison.com dating profile. I'm not suggesting, I mean, she knows a lot of things. I'm not suggesting. Okay, does he have to do it?
Well, again, it would what Colorado it depends. What Colorado looks to is what services the photographer makes available to the public. And if the photographer makes that service available to others taking pictures, for use on websites, then probably yes. But it depends on.
Okay, Justice, then I really will stop. Justice Jackson's example of the Santa in the mall who doesn't want his picture taken with black children. So if there's a black Santa at the other end of the mall, and he doesn't want to have his picture taken with a child who's dressed up in a Ku Klux Klan outfit. That black Santa has to do that?
No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws.